Welcome, everyone. I am Kent Holland. I am with Construction Risk LLC. I provide the risk management for PUA Arch Insurance. And with us today, we have Sandip Chandarana. And Sandip, would you like to speak about yourself and PUA?
Yeah, thank you. Thank you, Kent. So my name is Sandip Chandarana. I'm the director of PUA. We underwrite on behalf of Arch Insurance Company. And really, Kent's one of the best in the business. In addition to these webinars that he does for us, he also provides unlimited contract reviews to Arch Insureds. So make use of that. And for all attendees that are licensed architects and engineers, make sure you get your form into Kent's team to get your 1 hour of continuing education. But really, we truly believe that Kent distinguishes us from our competitors, one of the best in the business in terms of risk management. And with that, Ken, I'm going to turn it over to you. And, we look forward to hearing on this topic.
All right. Thank you, Sandip. And I think I will. Okay, I've muted you again, Sandip, so that you don't have to worry about any noise there in your room. Okay, so what we're going to do today is we're going to talk about ethical challenges. And this is written as ethical challenges for engineers, but the same principles, more or less, will be applicable to architects and other professionals as well. I actually, in doing this workshop, I went to the National Society of Professional Engineers, NSPE, website. I also talked to their director who handles all their ethical complaints that come in each year. And about each year, about 12 or so complaints are made against engineers for alleged ethical violations. And NSPE has a board, and they issue decisions every year. And those decisions are available on their website. So I went to that website and I looked at decisions. I guess I read all their decisions issued for the last 5 years. And I picked out decisions that I thought were of interest across the country. And many of these are situations that I've dealt with in my own practice, where I've represented engineers and these types of issues come up. As you know, I put more content into my slides than most speakers do. The idea being I'm not going to cover everything in the slides. I'm not going to try to read everything. These are for you to keep as a long-term resource. You can go and look at these. I won't even try to cover all the slides. Like the first few, I'm not going to cover them. I'm just going to tell you they're there. Look at them at your convenience. As we go through, I'll stop every once in a while and ask if you have any questions. And please type your question in the chat room, and I will try to answer it. And so with that, let's just go ahead and get started. It is an AIA registered course, and so if you are an architect, send me your AIA member number, and we will go ahead and get that filed. The lessons learned are listed here on slide 3. And the thing about the NSPE canons, and here are the fundamental canons that apply to engineers, and these canons apply to an engineer anywhere in the country. And what happened is NSPE issued a code of ethics. It's similar to what attorneys have with the American Bar Association. And those ethics are then either incorporated verbatim by the state's engineering groups in the state licensing statutes, or the state can issue their own code of ethics for engineers. I'm in the state of Virginia. We have not adopted the exact NSPE code, but we've adopted a code very similar. Other states just simply verbatim, they just take it and it's right inside of your licensing statute of your state. It says all engineers must comply with the NSPE code of ethics. Okay, so I've listed out the 6 fundamental canons here. The first one comes up all the time. You have to hold paramount the safety, health, and welfare of the public. That is number 1. That's the most critical of everything you do. And then you're only to perform services that you are competent to perform, issue public statements only in an objective, truthful manner, act for your employer or your client as a faithful agent or trustee. You need to avoid deceptive acts and conduct yourself honorably, responsibly, ethically, and lawfully so as to enhance the honor, reputation, and usefulness of the profession. So the NSPE code, again, it applies to every engineer that's a member of the NSPE. If you are a member of your local state NSPE, then these codes of ethics apply to you. If you are not a member, and it's individual engineers are who belong to NSPE, not corporate entities. So it's individual engineers. State codes have adopted these, and so these are very important coast to coast. Slide 6 shows you a lot of the rules of practice. I'm not going to read through all these, but they're here for you to look at. The first case I have says it's 16-6. What that means is from 2016, the sixth decision decided by the NSPE that year. It was actually decided in February, but it got filed in 16, so it's got the 16-6 date on it. It deals with business cards and advertising. I'm not going to read this. I want you to look at this later. I have enough slides later on this. We're going to really be rushed to get it through in an hour. So the next one is email signatures and providing engineering advice on social media. And the question is, well, what can an engineer do? Again, I want you to just read this at your leisure. The holding deals with a business card and social media. And now this is the first case I want to talk about. This is dealing with public health, safety, and welfare. It's NSPE case number 16-1. In this decision, the engineer observed that there was certain new testing equipment that was being designed by his company, and it was failing the outside testing that was performed by an independent lab, even while meeting the internal company test. So what they had was the engineer had a test, and it was showing that this equipment that they were going to manufacture was good, that it met the federal requirements. But the outside test showed that it failed. Well, he raised concerns with his supervisor at his firm, saying, "Wait a minute, there's a disconnect here. The outside test shows we're failing. Our inside test shows we're good. Maybe there's a problem with our inside test." Well, the supervisor ignored these concerns for many months, and then later the supervisor asks the engineer to issue a report that's going to go to the regulatory agency, stating that the equipment's on track to meet the required testing standards. Now, this supervisor of this engineer is not himself an engineer. He's a non-engineer supervisor. So the question is, what are the engineer's ethical obligations in this situation? If I were doing this live with you right now, I'd ask for anyone that had a comment or a question on this or a comment or an answer, just to raise your hand. So as we go through this, I think I will hesitate for a moment after I do each one of these and just ask if anybody wants to put in the chat room a comment or an answer, go ahead and I'll address it. Well, in this case, the decision, it was held that the engineer had a duty to report. He has an obligation to report to his supervisor his concerns that the equipment testing it is failing to meet the regulatory standards, and that if they ignore this recommendation, the engineers should report his concerns to his supervisor's supervisor. And I have a client in here, and that's not supposed to be client, it's supposed to be really if the supervisor ignores it. So if his non-engineer supervisor continues to ignore his recommendation to determine what's wrong with their in-house testing method, then he needs to report this to the supervisor's supervisor. So this must be a larger firm. They don't give you the firm names. They call them engineer A and B, so you don't really know who it was. So here they're saying report it upstream. That would be his duty. Issues to consider: confidentiality. There's a duty to maintain the confidentiality. This is spelled out in section 3.4. It's overcome, however, by the duty to health, safety, welfare of the public. So the comment that I have here, I see a lot of contracts that I redline on behalf of insureds that are or engineers that are insured by Arch Insurance, where the contract may say, you as a design professional have a duty of confidentiality. You shall not release any documents provided to you by your client or that are in any way confidential. It needs to have a caveat to that saying, provided you're not required to report that by law, regulation, or ethical obligation. So I routinely make that change in the contract so that you are able, without breaching your contract, to go ahead and report that. And I've had situations where an engineer on 2 different projects was forbidden by its client from revealing confidential information. And the engineer said, but I have to reveal this because if I don't, there's a real chance that somebody's going to get hurt, a real chance, an imminent danger. I must report this. I have a regulatory and an ethical obligation to report it. And the client said, nope, you can't report it. You'll be in breach of your contract. And in both those instances, I told the engineer, go ahead and report it. Better to breach your contract than to breach your ethical obligation. If they breach their ethical obligation, they could lose their license under their state licensing statute. So the idea here is fix your contract so that that doesn't happen to you. Let's talk about signing and sealing. Now this happens to be a manufacturer's drawings. This is case number 19-11. And in this case, engineer A is the lead engineer for a firm that's designing a plan to interface with a manufactured alarm and public address system. And it has existing equipment at State X Government Lab. The final design drawings are showing the interconnections between the manufactured alarm and public address system and with the state's facility infrastructure, such as speakers, alarm triggers. The preliminary drawing package consisted of two groups of documents. First group was an interconnection drawing specifically designed for the government client. And the second was the standard drawing from the PA system manufacturer of the cabinet, with modifications to facilitate the connection to the facility. But these were drawings by the manufacturer. Well, the client, State X Government Lab, requested that the final drawings be sealed by the engineer, including those drawings that were provided by the manufacturer that contained changes made by the manufacturer to their drawings that were required to interface with the customer's system, okay? Here are the Code of Ethics references that the NSPE referenced in their decision. I'm not going to read these, but they're here for your later perusal. Here's the holding. Engineer did not have responsible charge. That means direct control or personal supervision over the work of that independent contractor, that independent manufacturer. It was not involved in the initial design of the manufactured alarm and the public address system, and it did not have any authority or control over any changes that were made by the manufacturer to its drawings. So the better course of action in this case would be for the engineer to seal only the interface drawings that it created for the client. Also, the engineer should work with the manufacturer, if necessary, to get the manufacturer to have a different professional engineer sign and seal its own work so that the work will be completed in a proper professional manner. So in other words, the NSPE in this case said, no, engineer A did not have responsible control over the manufacturer's drawings. Therefore, it could not obey the client, the government agency that wanted it to sign and seal all of these drawings. Hang on just a moment. Julia, please come over. Julia, come help. I'm going to see if I can clean up my screen so you're not seeing my chat boxes. Can you get rid of these? All that stuff? Maybe move them over here or something. Yeah, there. Okay, good. Now you have a cleaner screen to look at, I think. All right. Okay, the next decision is 17-7. Again, it's going to be on public health and safety and welfare. The proposed traffic engineering infrastructure amendment to a local ordinance was going to be contrary to established engineering standards, and it was going to create a safety problem in the opinion of the local engineering community, including engineer A, who's part of that community. The city attorney, I guess, this was explained to the city attorney by the engineering community. The city attorney then attempted to explain to the city council why they should not adopt this proposed change that had been proposed by a citizen group. And the city voted to approve it anyway. So in this situation, city approves this traffic engineering amendment that the engineering community feels absolutely should not be passed. What, if any, obligations does this engineer A have? Now, this particular decision, I think, did not explain whether engineer A somehow worked for the city, was the city a client, or was the engineer just somebody who lived in the community? So I don't know which way it went, but this is what the decision held. The engineer has no duty to report the situation to the public authority, since the authority already knows of the facts and circumstances. So the NSBE says, well, the city attorney already told the city don't adopt it. So there's no reason for this engineer to go to the city and say, hey, you shouldn't do this. They already know it. But the NSBE said the engineer does have an obligation to further report this situation to appropriate local, state, or federal authorities in order to ensure that the relevant engineering standards are consistent with protecting the public health, safety, and welfare. So again, that public health, safety, welfare, NSBE felt was so important here that the engineer needed to go to all these other different government levels. Again, I could understand this if this engineer was actually employed perhaps on this project, that he had some direct involvement. But if he's only a citizen, that's his only involvement, I don't understand why he would need to do this. So I'm hoping that somehow he was an employee of the city government, and that's why he had this duty. Okay, next one is a decision of 2-02, and this was a decision from July 21. In this case, responsible charge and sealing of drawings. Agency B here hires consulting firm A to prepare rehabilitation plans for an underground facility lines. And these facility lines were owned by Agency B. So Agency B hires the firm A to do this rehab plan. Engineer A is an engineer at firm A, and he's qualified to do the design. Engineer B's engineering staff reviews the existing conditions and the relevant data for the utilities, and perform the design by recommending rehab methods for each segment of the utility. So it's Agency B's engineering staff that does these recommended changes. Agency B then provides recommendations to firm A, the engineering firm, that has licensed engineers, and they prepare CAD drawings for the work based on Agency B recommendations. So what happens here is the engineering firm prepares drawings, but these drawings are based on designs created by the Agency B, not the firm A's own designs. So the drawings are based on as-built plans and GIS mapping that's also provided by Agency B. So everything's really being provided by this agency. Engineer A reviews the drawings prior to submitting to the agency, and the agency ultimately approves the design and the drawings that are provided by firm A and engineer A. So now Agency B is ready to bid the work, and it requests that firm A affix a PE seal to the drawings. Well, the engineer informs the agency that because the engineer and firm A didn't make any engineering decisions on the project, but only provided drafting of all the content and the design that was provided by Agency B, how could this engineer sign these drawings? So the agency believes that since the engineer prepared the documents and reviewed them prior to submitting them back to the agency, that's enough to seal the drawings. What do you think? Can he do it? So what are the engineer's obligations in this situation? I'm looking at the chat box. I don't see any questions or answers here, so I'll just keep moving along. Okay, the NSBE provides their code sections that they referred to in making this decision. By the way, all of these decisions that I'm citing here, they're all printed right on the website. So you can go to and download them. Some of them are like 6 and 7 pages long. They go into great detail, and often they cite other decisions that were decided as many as 10 years earlier. And it really gives a wealth of information and background and nuances. So if you want to know more on any one of these, I recommend that you go to their website, nsbe.org, I believe it is, and look for these cases. It will be under their ethics section. Okay, so the holding is engineer did not have full responsibility for the design. It was not provided with the details of the utility conditions in order to design the repairs or to verify Agency B's repair methods. And it was only drafting agency B's design. The engineer A work did not meet the definition of responsible charge. Therefore, it would be unethical for engineer A to sign and seal these drawings for agency B. So this is really important. Um, I have had engineers in this situation, and they've told me that this decision really, they use this to go to their client or whoever they're dealing with and say, no, we really cannot sign and seal those drawings because we were not in responsible charge for that design. Okay, the next one is dealing with objectivity and truthfulness. This deals with an interesting situation of an engineer who has previously encountered differing site conditions on a project right next door to the project that he's about to design. So he's about to sign a contract, to design a contract for client B. Well, he advised client B that his work could be completed in about 150 hours. His best case scenario, 150 hours. Well, during the negotiations, this engineer knew that it had previously encountered differing site conditions on a neighboring project when it was doing work for a different client named Client C. Well, those conditions caused the engineer to significantly exceed the budget that it proposed to that previous client. And the engineer failed to disclose that information to this new client B. And then, of course, the budget was exceeded and there were ethical complaints filed, and the NSPE has to decide, was it unethical in this situation for engineer A, to fail to tell its new client, client B, of this previous differing site condition it had encountered right next door. And the decision is interesting. First, again, the code of ethics sections that are cited here says the engineers only should issue a public statement in an objective, truthful manner. They must be objective, truthful in their report, statements, and testimony. They shall include all relevant and pertinent information in such report, statements, or testimony. The engineer has an obligation to act as faithful agent for its client, and it has to have general candor and honesty in issuing reports, etc. Well, the issue here is, the focus is, did the engineer include all relevant and pertinent information when it was negotiating with its client? And what the board decided was, it was unethical in this case for engineer A to fail to disclose to this new client the fact that there were differing site conditions right next door. And if those differing site conditions were next door, why would those conditions not also show up on this new project? So the failure to disclose what can best be described as, quote, relevant and highly significant facts that engineer B clearly had within its possession was indeed unethical. All right, I'll stop here. I'm going to take a breather, and I'm going to ask if anybody wants to go to the chat box and ask me any questions on any of these cases we've talked about so far, or have a comment. This will be your opportunity to do it. So I'm going to wait for about 30 seconds for you to do that. All right, I don't see any chat questions, so maybe everybody's very happy with what I'm saying. You don't have any questions on this? I hope you're all following along, that I'm not going too fast or too slow, or that I'm not otherwise boring you with too much detail. Let's just keep going here. We're at slide number 26, public health and safety. This time, this deals with observed structural defects and then inspection by a county building official. So in this case, what we have is engineer A is hired by client B to conduct a building investigation to determine the origin and cause of a fire that resulted in financial loss. Well, during the investigation, the engineer, who is also a structural engineer, not just a fire engineer, he's a structural engineer, he observes that the building is structurally unstable. Well, the engineer performs a preliminary investigation of the building after speaking with the client and he concludes that there were recent structural changes that were made to the building, and that may have caused the roof to sag and the walls to lean outward. And this was because of insufficient lateral restraint. So the engineer also learns that following construction modifications, the building was issued a certificate of occupancy by the county building official. Although not imminent, collapse of the building is a significant danger. At least that's what the engineer believes. So the engineer immediately advises client B, and he calls the county building official. The county building official didn't bother to return the engineer's call, and the engineer also recommended to the owners to brace the building to prevent its collapse. So these are all the things the engineer has done. I mean, it seems like he's done a lot of good things. He's called the county. He tells the client, look, you need to brace your building because this thing could collapse. These are the things that the engineer has done. Is that enough? Did he do enough? The professional engineers, according to NSPE, must decide, after pointing out the decision, how far their obligation to seek corrective action reaches. Here, Engineer A brought his concerns to client. He also contacted the county building official who didn't return his call. And although the engineer did not believe the building was in danger of imminent collapse, he had an obligation to continue to pursue a resolution of the matter by working with the client and in contacting the supervisor of the county official, the fire marshal, or any other agency having jurisdiction to determine whether an investigation was warranted after the issuance of that certificate of occupancy. So you'll see in some of these a lot of the NSPE decisions, they don't really come out and say, well, it was unethical. What you did was unethical and you should be slapped on the hand. But what they do is they're giving guidance so that future engineers can look at these decisions and say, aha, this is what NSPE thinks we should have done. So in this case, what NSPE is saying is, look, the engineer needed to do more. They had an obligation to pursue a resolution of this matter by working with their client and going to, higher levels in the county official's office, the fire marshal's office, or even other agencies that might have jurisdiction. It shouldn't have stopped where it did. And, if you look at the situation where recently we had the condominium that collapsed in Florida, and in that situation, an engineer had been retained by the condo association. The engineer knew there were cracks in that building, and they were, gradually working at doing something about it, but the building collapsed before they got around to fixing it. And in that situation, I can tell you that went to settlement, and insurance carriers probably paid the biggest settlement I've ever seen. It was a huge, huge settlement to get rid of that matter. So this is a situation where, likely if you looked at that Florida situation with an NSP focus on it, NSPE could have said, yep, they had an obligation to move more quickly, do something differently than what they did. So this is a good decision to be, keep this in mind on your projects. Okay, next case is one involving misrepresentation. And this is an interesting case. What we have here, there's an engineer A. He's a licensed professional and forensic engineer. He's hired to be an expert witness by attorney B on a particular case. And prior to trial, this engineer learns that the expert witness for the other side has been representing himself to be an engineer, but he's not, in fact, an engineer. He's reviewing the engineer's credentials, and he discovers that this engineer has been misrepresenting himself to be a licensed professional engineer. He's been misrepresenting that on his website, on his stationery, on his signatures, all these places. And so this engineer goes and he tells his attorney B, he says, hey, our expert witness on the other side, he's misrepresenting himself. He's not a bona fide engineer. Well, subsequently, when engineer D is being deposed, it becomes clear that he was never even licensed in the state or the territory at all. This all comes out in a deposition. Well, just prior to a follow-up deposition of that same engineer a few months later, the engineer is no longer misrepresenting himself. His website's been changed, his stationery's been changed, his signatures have been changed. He no longer represents himself to be an engineer. Well, engineer A, who is the one that first noted these false credentials, confers with the attorney that he's hired by, and he says, hey, I think I need to report this to the state regulatory authority. This guy was misrepresenting himself. And the attorney says, no, don't do that. at least don't do it yet, because I think this is going to work to our advantage. If we get into a trial and this is their expert, and I can show this guy wasn't an expert at all, he wasn't even a bona fide engineer, he was fraudulently misrepresenting who he was, this can really help our client. So I don't want you to report this. We'll take care of it later. And so the attorney explains that he believes that the case will probably go to trial and that this misrepresentation will be exposed and is really going to be very good for their case and bad for the other side. Well, the NSPE code section that's referenced by the NSPE decision says engineers having knowledge of any alleged violation of this code shall report thereon to appropriate professional bodies and, when relevant, also to public authorities, and cooperate with proper authorities in furnishing information or assistance. So the engineer has an obligation under the NSPE code to report these alleged violations that it knows about. But on the other hand, his client, the attorney, is saying, no, don't report that yet. You know, this is really going to help our case. So let's keep it, you know, let's keep it under our shirt for the time being. Now, the holding says the issues here require balancing between these multiple considerations. And what the board basically decides is that the misrepresentation has stopped being a misrepresentation, that he's not currently misrepresenting himself to new clients as being an engineer. Therefore, we think you can wait while the board, the NSPE board, takes seriously these misrepresentations. A balance must be struck between the multiple considerations here. And so what the board says is it is okay in this case to wait and report it later. You don't have to report it right now. And I'm going to give you an example. I mean, this happens. You know, I handle the Arch hotline. So if you have a potential where you go, I wonder what's going to happen with this issue. I don't have a claim against me. This could turn into a claim. Will you call me on the Arch hotline and I will assist you? Well, we had a situation about 2 years ago. We had an engineer call us on the hotline, and their issue was it was a firm that had purchased a small engineering firm. They were merging a new firm with their larger firm. And the new firm they bought was specifically, they had like 2 engineers in that firm. And the main engineer in that firm designed wind turbines in various states around the country. And he did other structural design. Well, this guy had let his license lapse. He simply had not renewed his license. And the new firm that bought them didn't know this. And here's this engineer who's out there designing wind turbines and other things. I think they were in 8 different states they did design. And some of these actually got constructed. And they were constructed under, you know, with a design that wasn't by a bona fide engineer at that point. They called me, they're like, what in the world are we going to do? We have a major ethical issue. We violated, you know, our licensing statutes in 8 different states where we shouldn't have done this without a license, and we built things. So what we ended up doing was we went out and we talked to every one of the state licensing boards. We said, you know, we're sorry, we didn't know this happened. We were going to fix it. We hired people to come in, do peer review of the designs where things were constructed. We came in and we looked at the construction, and in each case we prevailed. We convinced each one of the state regulatory bodies not to issue any sanctions against us. So we spent some money. I hired an attorney that was really proficient at this, and he and I took care of it, and it never turned into a claim. And this was paid for, by the way, by Arch under pre-claims. It's not part of your deductible. We pay it in order to avoid what would otherwise be a very large claim. So that's one example of this. Another example happened in the state of Maryland, where I'm a licensed attorney. And in the state of Maryland, what happened is there was an arbitration proceeding where a contractor had a claim by his subcontractor. It was in arbitration, and the contractor hired an expert engineer to testify on its behalf, saying that it met the standard of care, the subcontractor is not entitled to recover. Well, during the arbitration, it came out that the so-called expert was not a licensed expert engineer. He was not a professional engineer. He had not even graduated. I don't think he had graduated engineering school. So he was bogus. And that came out, and as a result, the contractor lost the arbitration in the amount of about $2 million to the sub. Complete loss, $2 million, because the only way you can defend a professional liability claim, you have to have an expert witness. You can't just have an attorney or a general person say, oh, no, that wasn't negligent. Only an expert can say that. Got to be a licensed architect engineer. So what the contractor did was then turn around and sued the engineering firm that it hired, saying, you know, you gave us a bogus expert. They went to court and they won. They got a $2 million judgment at a jury trial in Maryland. That got appealed to the highest level in the state. And believe it or not, the Court of Appeals of Maryland held that the engineering firm did not owe anything at all to the contractor. Nothing, even though this ethical violation had occurred. And the reason was there was a waiver of consequential damages clause in that contract, mutual waiver. And I routinely add that mutual waiver to all of your contracts, saying that both parties waive all consequential economic losses against the other party for lost profit, lost blah, blah, blah. It goes on. I kind of define what those are. And it had that clause. And the court said, look, these are both big entities. They had attorneys. We will honor the contract. The state of Maryland will not rewrite your contract. We will honor your contract. You waive consequential damages. Therefore, you get zero. Really an interesting decision. I used to talk about that case and tell you who it was, and the general counsel for the firm called me and said, would you please not tell anybody that was us? I'm like, okay, I won't use your name anymore. Okay, next decision is 18-7. We're on slide number 32. We're moving right along. I think I have about 40 slides, so we're doing fine for time. If anybody has any chat room questions or would like to have me talk a little bit more about any of the cases, please let me know. Okay, this next one, signing and sealing documents, electronic seals and signature. Now, this is an interesting case where you had an engineer, solo practitioner in private practice. He performs engineering design services in a rural area. And this engineer recently established an internal process for using electronic seal and signature protocols. After he finalizes his engineering documents, he finalizes them electronically. Well, those electronic signatures and seals are permissible in the jurisdiction where that engineer practices. Well, afterwards, the engineer is retained by a client in a nearby rural community to perform engineering services in connection with a client, client B, for a private industrial building. Now, the engineer doesn't advise this new client in advance concerning the fact that this engineer is using electronic seals and signatures. And unbeknownst to the engineer, this client doesn't have the necessary software to permit it to validly exchange the electronic information with the engineer for these signed, sealed documents. So as a result, the code official approval and the financing and the construction, all of this is delayed because they can't transmit this electronic documentation. Apparently what happened was the engineer had to go back and redo the documents, maybe as 2D drawings or something that it could use to physically then go over and transmit this by hand to this client. Well, that delayed the whole project and created significant costs. So did the engineer violate ethical obligations? The facts and circumstances according to the MSPE and the considerations of all these other cases that they cite in their decision involving signing and sealing engineering documents would, show that indeed maybe the engineer may have had an ethical issue, maybe not. In this case, the engineer did not perform an unethical act. The facts indicate that the engineer should, however, have taken appropriate steps in advance to communicate to its client how it was going to transmit its reports, its documents. The engineer should have clearly communicated this fact either at the time that it was being selected or in the contract. And its failure to do so conflicted with its obligation to act for every employer or client as a faithful agent or trustee. Well, the NSPE concluded that although the engineer's actions were not unethical, the engineer should have taken appropriate steps in advance to communicate to the client how the engineering deliverable would be transmitted to that client. So again, this is one of those kind of a nuance that you go through the whole thing and you say, yep, I see where the NSPE is going. And they say, yeah, could be an ethical issue. And this is what the engineer should have done, but they didn't say it was unethical. Now, I can tell you that I've had a situation similar to this where the engineering company um, did building information modeling. And this is before it was called building information modeling. I've been doing what I do for a long time. And so I was the program risk manager on a project-specific insurance policy issued by one of the large insurance carriers on a football stadium. And this would have been back in about 1999 or 2000, about that time frame. And what happened was the engineer prepared all of their steel drawings in something that there was a name for it. It wasn't called BIM, but it basically was all electronic design of the steel for this building. That's what the engineer used, very elaborate electronic system. And maybe everything would have gone fine, except for the steel fabricator was located in Louisiana. And I think the guy didn't even have a computer, let alone know how to transmit these huge steel drawings electronically back and forth with this engineer who was located up north. And so what happened was the engineer had to redraw every one of these electronic drawings. The engineer had to sit there in its office and redraw them all into 2D drawings with the old-fashioned bubbles showing all the changes and all this. It took forever. Now, it's a football stadium. You can't be delayed in opening the game or there are going to be huge liquidated damages. So they just simply work around the clock to get this done. And I kind of laugh. I think the stadium should have been named for the insurance carrier because the insurance carrier paid every conceivable insurance policy on this project. And a big part of it was because of these drawings that were drawn electronically in a manner that really couldn't communicate between the parties. And probably the engineer should have figured this out beforehand. So that's just an example that shows you, firsthand why I've included this decision in this deck today. Okay, that was 18-7. Now let's move on to 18-12. This one deals with the issue of fiduciary duty. When I review contracts for you, I routinely look for wording that would create a fiduciary duty because there is no insurance. If you agree to a fiduciary duty, you're not insured for that. You're insured for negligence. A fiduciary duty would say that you've got a duty that goes way beyond standard of care. You've got to put your client head first before everything else, including your own common sense and duty. So the client comes first. So in this case of 1812, what happens is an engineer he's a professional engineer in private practice. He's negotiating a contract with his client. And there's a contract provision. It says engineer shall act as a fiduciary on behalf of the client in performance of engineering services for the benefit of the client. Okay, this one actually said you will be a fiduciary. Normally, the client will not be so bold and blatant. They don't want you to realize they're making you a fiduciary. Instead, they use the words trust and confidence. So I'll say the engineer shall act with trust and confidence. We're in a relationship of trust and confidence. Well, courts interpret those words, trust and confidence, as creating a fiduciary duty. So whenever I see that in a contract, I strike those words and I say instead, we are going to be in a relationship of good faith and fair dealing. That just means you're going to honor the contract. It doesn't create any special duty. It just means you're not going to be negligent. It's fine. No problem with that. And almost every time I make that change, your client will agree to it. That's just normal. Those are the normal words you should expect. So here, the board explains a fiduciary is a person that's required to act for the benefit of another, here the client, on all matters. The fiduciary owes that other party the duties of good faith, trust, confidence, and candor in all matters within the scope of the relationship. So here the question is, would it be ethical for the engineer to agree to a contract provision to act as a fiduciary on behalf of the client? Well, I can tell you some reasons why I think it might be unethical. One, if you're an engineer on a project and you do the design, often you're going to have a second phase of work where you're going to be doing contract admin for that client, meaning that you're going to be reviewing requests for information, change order request, You might even be named in the policy as the first level decision maker. If a contractor has a claim, they have to come and you have to make the first decision before it gets arbitrated or litigated. You are in a quasi judicial role. You have to act with impartiality. You can't sit there and say, well, my client, the owner, is paying me for this, so I'm just going to reject all these change orders. It doesn't work that way. You've got to be impartial. But if you've created a fiduciary duty, I think that goes against your impartiality. I don't know how you can be impartial when you've committed to be a fiduciary for your client. This creates a real problem. So here's how the NSPE handled the question. They say, under the fiduciary liability standard, a standard higher than the professional standard of care is imposed. The engineer would be required to place the interest of its client ahead of the interest of other parties, like the contractor or even itself. Generally, a fiduciary is a person that's required to act for the benefit of another on all matters. And the fiduciary owes the other party duties of good faith, trust, confidence, etc. that we've already talked about. And then it goes on, it says, the concept of fiduciary duty raises two significant issues in the context of professional engineering practice. First, it imposes a higher standard of practice that could not be insurable. And this higher standard could, create a greater personal and professional liability. And then I'm not going to read the rest of it. It goes on and on. You can read this at your leisure. But basically, it says, secondly, a fiduciary duty could require the professional engineer to place the client's interests and concerns above all others and potentially interfere with the professional engineer's primary ethical obligation to hold paramount the public health, safety, and welfare. All right. The holding is the BER would strongly urge any professional engineer agreeing to a fiduciary duty and fiduciary liability that comes with that duty to do so only with the full knowledge of their employer and with appropriate advice from their legal and insurance counsel. And notice they say insurance counsel, because I don't think there's any insurance for this. This is what I always tell you. Do not agree to fiduciary duty. You're not insured for that. So don't, if you see that in your contract and you sign that without getting your attorney and your insurance broker or your insurance carrier to weigh in on it, you're making a mistake. Okay. So their conclusion is they're not going to say that entering into the agreement is an absolute breach of your ethics, but they're saying the engineer should negotiate additional language when it's agreeing to that kind of fundamental ethical obligation. Okay, so be careful. All right. The next one is 18-9. This one deals with public health and safety. And this one is building code to address an environmental risk. So in this particular case, what we see is the engineer is retained by a client who's a developer, and they're going to perform hydrodynamic modeling and coastal risk assessment in connection with potential climate change and sea level rise. Now, the geographic area in which client A is planning to build has no building code in place. And based on newly released information, as well as recently developed algorithms that include newly identified historic weather data, the engineer believes that the residential development project should be built to the 100-year projected storm surge elevation. And this is because due to public safety risks. Okay, now, because of the increased cost, the owner says, no, I don't want to do that. I'm not going to agree to build it to the 100-year floodplain level. I want you just to build it to what I am allowed legally to build. Okay, the Code of Ethics references that are referenced here by the NSPE are on slide 39, and here's their holding. While the desire of the developer to reduce its cost is understandable and a legitimate consideration, when weighed against the apparent substantial risk to life and property, the latter consideration must prevail. The engineer should consider or should continue to pursue discussions with the client to convince the client of the danger in which the future residents as well as the general public could be placed. And if the client refuses to agree to the engineer's design standard, the engineer should withdraw from the project. The engineer should also consider contacting local government officials to advocate for implementation of appropriate and updated regional-wide building codes. I mean, there are no building codes in this jurisdiction. How can this be? And they're saying, look, here the engineer ought to at least go to the building officials and say, look, you need a building code. And the engineer should continue to pursue discussions with the client to convince that client of the danger in which the future residents as well as the public are going to be placed. And if the client refuses to agree, then the engineer should withdraw from the project. Now, I was at a program a week ago for the American, it used to be the Consulting Engineering Council. I still call ACEC that, but that's not what its current name is. But anyway, I belong to the Legal Counsel Forum. So we've got all the attorneys in-house and outside for engineering firms. And an issue came up. One of the attorneys there said, well, that he had an engineering client working for a large developer, and that developer was willing to spend an extra almost $1 million to peer review this project and do all these extra things to make sure the project was going to be great. My view is that is a very unusual client. All the clients I see today, they want to go cheap. They want to save money. And the engineers that are calling me on the hotline, and I had a hotline call 3 weeks ago from an engineer. And the issue was this. The engineer said, I have a client, and I'm telling them that in my opinion, the code requires me to do this, this, and this, and this. And the client says, no, I do not want to meet that code requirement on my project. I want to go cheaper. I want you to only do this. What should I do? And I wrote back to him. I said, you need to walk away from that client. You need to tell the client that you cannot do this work in violation of the code. You must not do it. The code establishes the minimum standard of care. If you violate the code, you are per se negligent. In the event something happens wrong on that project, you're liable. You must meet the code. You must not agree with a client to do something in violation of the code. So I put this decision in here because of the fact that I just dealt with that on a hotline call. Very important issue. All right, that brings us to our end. If you have questions on the content of this course, this is my email address, my phone number. If you need a certificate of attendance, just send a request to me. If you have an insurance program question, stand-up's address, phone number, and email is also on this slide. And now we've got 5 minutes to handle any comments and questions you may have. And I certainly hope that someone in our chat box today would like to ask a question or make a comment. So go ahead. Maybe I'll just open up the room and let me talk. Julia, can you come over here, please? I just do this, right? I'm going to unmute all. Yeah. Okay. They're still muted. Oh. Okay. I've invited anybody that wants to talk. You can unmute yourself, and you are welcome to actually talk on the phone line. Otherwise, you can put a question in the chat box, and I'll be happy to answer it. No one. All right.
Kent, Mark here.
Hey, Mark.
Hi. Wondering if this will be available, posted to be available to watch later?
Yes, absolutely, Mark. If you'll just send an email to me.
Okay.
We will send you a link so that you can watch it, and you can share that link with anyone else to watch the video and the slides. And also, we will send you a copy of the slide set.
Excellent. Thanks.
Yeah. Thanks for asking, Mark. Anyone else?
Could you define fiduciary duty?
Will I define it?
Yes.
So let me see. I'm gonna go back to the slide. I think that the NSPE may have done somewhat of a job of doing it, at least two things. Let's see. Here we are. Because I'm not sure that I would actually give you a Black's Law Dictionary definition, but a fiduciary has a duty to, it's almost like if you are a trustee of somebody's bank account, then you're a fiduciary. You must take care of them. That is your obligation. You have a duty that goes beyond a standard of care. You are really acting almost totally for that person. And so the concept, as explained here on the slide number 36, explains the kind of detail. It says the standard could expose professional liability, and it goes on. I think it says the example, fiduciary duty would create a conflict between a professional engineer's obligation to a client to maintain confidentiality, would interfere with the professional engineer's paramount duty to report a situation that could endanger. Well, why would it do that? Well, because as a fiduciary to a client, that client, like I've had 2 cases where this happened to me. In 2 cases, the confidentiality clause in the contract prohibited my engineer from reporting environmental conditions. Now, in one case, the engineer was out doing environmental site assessment work along a side of a highway. And doing this phase 2 work, he found there was pollutant literally right on the strip, right beside the highway. And the client said, oh, no, you can't report that to anybody. And it was actually a private road. You can't report that. You must not report that. That's on my private land, and you signed a confidentiality agreement. Now, if we had signed something saying we were a fiduciary to this client, then we literally would be bound to never report that because it was contrary to the client's interest. Because if we reported it, then the government's going to make that client clean up all this pollution on its land. And what that client was saying, I don't want to report that to anybody. I'm just not going to bother to develop the land. It's far cheaper just to let that land sit there. Maybe I can even sell it to some sucker that doesn't know about it. But I don't want to report it because now I'm going to incur millions of dollars. As a fiduciary duty, you would be bound to not report that. But under your ethical obligations, you had to report it. And even under the state regulatory obligations for environmental, that engineer had to report it. So I told the engineer, look, you've got to violate your contract. You have to report that. So they reported it. Client was very upset with them, threatened to sue them. And I said, look, you're going to win. And it's going to cost us some money to defend you, but there's no way a jury is going to find in favor of that client. But you are clearly violating your contract. Well, that what had been a decent client never gave him any more work. So that ended that contractual relationship on a sour note. So that would be the type of a deal where a fiduciary duty it bounds you to be more committed to your client than you are to the health, safety, and welfare of the world at large or to your ethical obligations. Real problem, real problem.
Thank you.
Anyone else? You got 2 more minutes. Happy to answer any questions. I'm happy to have a discussion with you on anything I don't know about. Just love to hear from you. Well, all right then. That will wrap us up for the day. I appreciate your being with us. If you have anybody in your office that you feel you would like to share these slides with, we will provide you with the link so that you can share the video and the slides. And we will see you probably in about 3 months. We'll be doing another one. So look for us then. We'll send you a note. Thank you.